February 27, 2023, City of Tualatin work session. First item on our agenda tonight is a training session on public meetings, land use hearings, and conflicts of interest to be led by Chad Jacobs, our city attorney. Welcome.
Thank you. Good evening, everybody. So we're going to do a little bit of a training. If I can get this to work, it's still not working again. There we go. And what I like to do in these is really give you all an opportunity to talk about the issues that you have most concerns about. I have a PowerPoint presentation that I'll use as a general outline to guide our conversation, but I'm not going to go through each slide in a lot of detail. I'm not going to read like every little point on each slide. You do have the materials in your packets, so you can use them as a reference. And really what I want to do is just have that for you as a reference to be able to refer to in the future in case you're wondering, oh, what was Chad talking about? What was that issue again? But the main goal for tonight is not for you to become an expert on these laws. You may already be one, but if this is all brand new to you or it's a refresher to you, I'm not hoping that by the end of these 45 minutes that we have that you're going to know these things like the back of your hand. That's why you have your amazing staff. And my goal is to really just for you to be able to say, I think that might be an issue. I should go talk to Sherilyn about that. And so if we can get that goal accomplished tonight, then we have achieved everything and more. So that's really the main goal. So don't feel overwhelmed because it's a lot of information that's going to be thrown at you. Don't feel like you've got to really know this stuff. Because again, the goal is just to be able to recognize the issues. As the mayor said, we're going to talk about a couple different topics, your authority, public meetings, land use, and a little bit on public records. I'm going to try to, again, just use this as an outline. I'll probably go quickly, but if you have questions, interrupt me at any time. Again, this is really about you all and making sure that you're getting the information or getting the questions that you have answered so you get the most out of this. I do this a lot. I know this stuff like at the back of my hand, so I don't really need to repeat it. So, whatever you all sort of want to get out of this, let's talk about that. All right. The first thing I always like to remind folks of is what your authority is as an individually elected official, which is basically none. As an individual elected official, you can act as a body as the city council, but unless the council or the charter delegates authority to you individually, you've got no authority to act on behalf of the city. I just like to remind folks about that because really what your goal and your job to do is to set the policy for the city acting as a body. So a lot of times you'll get information from staff or information from the city attorney's office that says, remember what the council as a body wants to do, you can do blah, blah, blah. But it's really the council as a body that gets to make the decisions on behalf of the city, not individuals. Your council rules also explain how you present information to the public when the city is taking an official position on something. If you're there representing the city, you need to take and point out that position that the city has taken. If you're going to take a personal statement or a personal point of view that's different from the city's position, you need to make sure that you're explaining that to whomever you're speaking with. So it's very clear that this is on you and not, this is your personal opinion and not the city's official position. Okay. All right. So next thing I'm going to talk about is public meetings, and hopefully you're somewhat familiar with this, but as you may know, state law, the public meetings laws require us to have your meetings occur in public. So anytime you make or deliberate towards making a decision, we need to do that in front of the public. And the goal for that is transparency, that the public really gets an opportunity to see what the decisions the city's making and how those decisions are being made. There's a bit of a sort of issue with state law right now that there's actually legislation pending for the legislature this session to clarify this, but so far it's been clarified by the courts about what is a meeting. And the reason that that's a little bit confusing is because state law basically uses the word to meet and meetings, and the courts have said that that means two different things. And I'll explain that in a little more detail. The first part is that, a meeting requires the convening of a governing body of a public body, which is the city council, for which a quorum is required in order to make a decision or deliberate towards making a decision. So for a meeting to occur, what has to happen is that you have to have a quorum. So for the city council, be at least 4 of you, have to convene in the same place, and you have to make a decision or deliberate towards making a decision. Once you've done that, you have a meeting and you have to follow all the requirements of the public meeting laws, have notice, have it be open to the public, take minutes, all those sorts of things. You've got to do all that to comply with the public meeting laws. Importantly, if you're going to do on-site inspections, there's a specific exemption for that from the definition of meeting. It also doesn't include attendance of the city council at any national, regional, state association which the public body or members belong. So to the extent like you're going to an LOC meeting or an LOC training, something like that, that's not going to be deemed a meeting just because all of you happen to be there. So the big question becomes, one, when does a quorum apply? And two, when can you have a meeting occur when you've got less of a quorum together, but you've got subsequent conversations or serial discussions? So I'm going to talk about those two things next. The first thing to remember is a quorum is basically a majority. So that's 4 of the 7 of you. So if 4 of the 7 of you are getting together, that's a meeting. If you have subcommittees, so let's say you create a subcommittee of only 3 of you, then the quorum's only 2. So that means only 2 of you constitute a quorum. And for the 2 of you, you can't get together and talk about issues that are within the jurisdiction of that subcommittee. So for example, if you create a subcommittee on finance issues, then you've got a finance subcommittee. Any 2 of those 3 members of the subcommittee can't have one-on-one conversations to talk about those issues. So that's often why in a body of the size of the city council, it doesn't make a ton of sense all the time to have subcommittees. But if you are ever going to create that, just know that the quorum requirement actually shrinks. So then meet. So that's the serial meeting issue. And basically what this happened, what the court said is that this term meet is different from meeting, and that you can't actually violate the public meetings laws, even though a quorum of you are not together at the same place at the same time deliberating towards a decision or making a decision. And what they said is that you can have a series of communications, and that's where the idea of serial meetings comes into play. And a series of communications where a quorum of the council deliberates towards a decision or makes a decision is also subject to the public meetings laws. So let's talk about a couple examples of that. So 5 of the 7 members of the council are all at the same school play and start discussing the merits of whether to propose the creation of a city program that would support performing arts in the arts in schools. Those members have met in public, and that's your typical definition of what a meeting is. That seems pretty clear to most people, right? But then when you talk about a serial meeting, an example would be a council member forwards an email discussion they had with another member regarding a matter that is pending before the city council to a 3rd member. The 3rd member then forwards the email chain to a 4th member, who then forwards it to a 5th member, because the email messages in the aggregate include a quorum of the board of members, here 5 of the 7, even 1 extra. And the purpose of the communication was to deliberate towards a decision. Those email exchanges in the aggregate constitute a serial meeting. So even though you were all never in the same place at the same time, the communications didn't occur at the same time, those series of emails constitute a serial meeting, which then violate the public meetings laws. Another example of this, which is a little less common, or maybe more common in today's age, is social media. You can also have serial meetings when people communicate via social media. So let's assume a citizen posts a comment on the city's Facebook page about an upcoming land use hearing, and the comment generates discussion. 3 members of the council make comments and share opinions on the Facebook thread. A 4th member reads the comments and also makes a comment. Because a quorum, now 4 members have communicated opinions on the social media site on a matter that will require a vote before their body, the members have created a serial meeting. And so this can happen in multiple ways. Where it gets really confusing is what happens when you've got a member of the public who's coming to you and saying, hey, I just talked to the mayor said this, I talked to the council president, she said this, I talked to this councilor, they said that, and you go through the whole process and they're sharing this information with a quorum of you. How do you handle that situation? Because you can have a situation where an individual serves as a conduit to create a serial meeting. And so with staff, they're pretty well trained not to do that. So when staff meet with you one-on-one, they share information with you, or our office sends information with you. We know not to share the opinions that we've heard from other counselors with a majority of the council so as to avoid this issue. But members of the public, they don't necessarily understand that. So the way to handle that is really if someone begins to talk to you about, here's what so-and-so said on the council, just try to politely cut them off as quickly as possible and say, I understand you want to tell me what they say, but I can't really talk to you about what they think because we have to do that in a public meeting. I'm not going to tell you that it's always successful, that it's going to work every single time. But at least if you make that effort, it's much less likely that a court or the district attorney or anyone's going to say that you did something wrong in those situations. So take those steps to protect yourself. make sure that you're trying to explain to the member of the public, hey, here's why I can't really have you tell me what other people are doing, because that could cause a meeting violation for me and for the rest of the city. Any questions about serial meetings?
Not on serial, but the other.
Yep.
one. If we're in a situation, I think this could happen quite often. So there's maybe 5 of us and we're at a fundraising event. Is it okay for us to sit at, I get we cannot talk about, make decisions.
Yep.
But is it okay to sit at the same table and converse, or is that an appearance, more of an appearance thing?
So you're talking to a lawyer who's always going to tell you, don't do it. I can't tell you that it's illegal. What the problem is you see people see you there and they see you all talking, and then someone makes a claim that you had an illegal meeting. And then the burden sort of shifts to you all to prove a negative, that you didn't do that you weren't having those conversations, that it was purely social. And even though that burden doesn't shift to you from a legal perspective, it's not like you've got to prove in a court of law that you didn't do that. But for the public perception, and people complaining about that the council's holding illegal meetings, you're going to have to prove that in the court of public perception. And it's just very difficult to do. So I would advise, to the extent that, 3 of you are sitting at a table, 4th person comes over, one of you should get up and
We
leave.
should just kind of separate,
Yeah.
and then it's okay. Okay.
Has this happened before? Has somebody taken this process to Matt before and says, I saw them, they had me, has that happened before?
Absolutely.
It does.
Yeah. And certainly, in cities where there's a much more divided council and a lot more controversy, it happens more often. Matter of fact, it often happens when one counselor complains about the other counselors. So it's not even just a member of the public. It could be, just because there's a disharmony on the council, it creates situations where one counselor is complaining against the others.
I have another question going.
Yeah.
Sorry.
No.
If you're in a situation where, say, you're going in front of another governing body, say Metro, for
Yeah.
example, and you want to speak as an individual, but you want to make it clear that you've got a background knowledge, is it okay to say that you're on city council, but you're speaking as an individual, or should you leave that off?
Yeah, you can say that, you can use your title for identification purposes, but you need to be very clear when you're doing that. So you would come forward and say, I'm here on my own personal behalf, even though I am a city councilor. I just want to be very clear that the opinions I express today are my personal opinions and not those of the city. And that, you'll see that all the time, and people do that quite often.
Okay.
Okay, get back to where we were. A couple other tips just to keep in mind for public meetings, to avoid sort of the serial meeting issue. If you get an email from staff or from our office that's addressed to the full council, don't ever hit reply all. If you need to reply, just reply to the individual who's sending it, because that's the reply all button is probably the easiest way to commit public meeting violations. Really think about the different forms of serial communications, both email, telephone, face-to-face, and social media postings. One issue came up recently for another client where people were posting comments on a newspaper article. It wasn't even social media, but the comment section after newspaper articles, and there was an issue of a potential serial meeting there. So just really random places where you don't think it's necessarily going to occur, it can occur. So be careful about that. Definitely try not to use staff or other individuals as intermediaries. And we already talked about the idea of the public and how to handle that. So in addition to just your regular meetings, there are limited circumstances where the city council is allowed to meet in closed session or an executive session to discuss matters privately. A couple of issues related to that. One is that you really need to make sure that when you're in an executive session that you limit your conversation to the topic that was noticed, because once you sort of stray beyond that topic, you've created a public meetings law violation. And the Ethics Commission actually has jurisdiction over executive sessions right now, and they will do investigations, listen to your executive session tapes, and really ding you for straying beyond the scope of what was noticed. So you really need to, make sure that you're sticking to what was noticed. In addition, for executive sessions, Oregon is the only state in the country that allows media to attend executive sessions. So the media is allowed. They're not always there, but they are allowed to attend your executive sessions. They are technically not allowed to report on what is talked about in the executive session. However, they can use what they learn in the executive session to gather information in other ways. So quite often you have an executive session, it's at your night meeting, The next morning, staff comes in and they've got a public records request from that member of the media asking for all public records related to whatever topic you just discussed. So, just know that the media, if they attend, they may begin to report on those issues. One thing that I do always like to tell people about is that you should not talk about what is discussed in executive session outside the executive session. And this hasn't happened in a while, but for about 10 years ago, the media, would attend the executive session. They'd wait for folks or walk out to the cars with them or in the parking lot afterwards. And they'd say, hey, will you just clarify for me what you were talking about in the executive session? I didn't quite understand what you were saying. And then you're like, yeah, well, they were in the executive session. So let me clarify, because I want to make sure that I'm not misrepresented in the press. I want my opinion to be understood. So you start talking to them in the parking lot about what you just said. Well, now they gather that information outside the scope of the executive session. They can fully report on it. So you just have to be very careful about having any discussions about executive session topics outside of the executive session itself. If you have questions about, how to respond to the media or something like that, always talk to your staff, because they'll be able to say, okay, here's how we should handle this or not. But just know, and knock on wood, the media hasn't really played those tricks very much lately, but for a while it was going on quite a bit. And so we really had to tell people, and here I am 10 years later, still telling people the story just to make sure that doesn't happen again. For executive sessions, though, we will, work with staff. Staff will always be the one providing the notice and making sure that you're doing it all correctly. The other important thing about executive sessions is that you can't make a decision in the executive session itself, that we always have to come out of executive session before we can vote on the matter. You can reach a consensus in the executive session and say, okay, we all agree that this is the path we want to take. To actually take any final action, you need to come out of the executive session to do that. And you can't come out of an executive session to take action unless before going into executive session, you inform the public that you might do that. So if you ever think that you're going to take action afterwards, even if it's a possibility, you always want to make the announcement when you're going to executive session that you may return afterwards to take action if needed. If you don't make that announcement, then you're prohibited from actually taking action until a next publicly noticed meeting. Okay. Then this sort of follows up. This is the slide I was looking for when you're asking a question. Social gatherings. It does not apply to social gatherings, but again, it must be purely social. You should avoid any discussions of official business. And that, the idea of all sitting at the same table or riding in the same car or whatever else creates a perception issue. And you'd want to try to avoid that if at all possible. Okay, I'm going to get into land use hearings, but before I do that, any questions at all about public meetings? Okay, so land use hearings are part of a public meeting. We conduct our land use hearings at public meetings. So that's why it sort of falls right after public meetings. And there are two types of land use hearings that you're going to conduct. One is legislative, and one is quasi-judicial. And the difference between the two is really important because depending on which it is, dictates what procedures that you have to follow and what sort of actions that you as an individual are allowed to take, both at the hearing itself and outside the scope of the hearing itself. So the first thing I want to do is make sure that everyone understands what the difference between those two are. The first one is a legislative hearing, and that's really, and the easiest way to think about it is where you are creating the criteria to apply to a future decision. So where you're actually enacting a law and saying, if someone wants to do this type of development, they have to meet these kinds of standards. So when you're actually establishing those standards, that's the legislative part of it. That's sort of where you're acting as a legislator, you're creating the standards, you're creating the rules. And it's important to think about the idea that you're not required to actually make that final decision in most circumstances. Like you can do that now, you can do it later. There are certain times where Metro dictates that we have to do certain things in the land use process. But for the most part, a legislative decision is where there's no hard, fast deadline for you to make a decision. Quasi-judicial decisions, on the other hand, are where you are acting as a judge and you are applying specific facts of a situation to the criteria that was already established in the legislative process. So like the hearing that you're going to have tonight, that's a quasi-judicial hearing because you have a set of factors, criteria that you're going to look at. You're going to have facts that you're going to get presented during the public hearing, and you're going to apply those facts to the criteria and make a decision. Also with the quasi-judicial decision, you're required to make a decision. Someone has filed an application and you either have to say yes or no. We don't get to just sit on it and say we're not going to make a decision. So those are the two big differences between the legislative and quasi-judicial. And why it's really important, again, is that quasi-judicial hearings impact due process rights of the individuals involved. And what that means is basically, in the most simple sense, is that they deserve a fair hearing. And in order to provide them with a fair hearing, we have to follow certain procedures. Where with the legislative process, there aren't due process rights that attach to any one individual, because the decisions you're making affect a broad group of people, not just a small group or one individual. And so with a quasi-judicial hearing, there are procedures we have to follow. And the first thing you'll see is that in a quasi-judicial hearing, the mayor will read a script, and as part of that process, will explain sort of a whole bunch of information to the participants about how the process worked, what's going on, the criteria that we're going to apply, all that information. The next step is that he will ask each of you if you have any disclosures to make. And those disclosures include ex parte communications, any bias, and any conflicts of interest. And in a minute, I'll go through each of those to explain those in a little more detail. Then we have to hold the hearing to take evidence. And it's really important to understand that you have to base your decision on the record that is presented and apply it to the applicable criteria. So to the extent that, individuals come up and they want to give testimony about matters that aren't relevant to the applicable criteria, that's not really information that you are permitted to take into account when you're making your decision, because you really have to say, here's the facts that we're looking at and how do they relate to this criteria that applies. If the facts that they're presenting don't apply to the criteria, it's not really something that we can rely on to say yes or no to whatever the application is. We really have to focus on the criteria that applies and how the facts involved relate to that criteria. Does that make sense? It's land use, so it's all clear as mud. Okay, so at the hearing, we take evidence, and generally what happens is staff will give a presentation, sort of explain, here's how they view the situation in their staff report. The applicant will have an opportunity to speak. Then individuals who are in favor of the applicant can speak. Individuals who are neutral on the application can speak, and then individuals who are opposed can speak. The applicant generally then has a rebuttal time where they can come up and address the issues that were raised by any other public comment. And then finally, staff will come back and sort of close out the hearing process and sort of explain anything else they feel needs explaining after all the various comments come in. Once that is done, we close the public hearing, and then you all have a chance to deliberate. So you're going to say, okay, based on all this information that we just got at the public hearing, and based on this criteria, how do we think this decision should be made? And you all have a chance to deliberate. Yes.
The Q&A from the council to the applicant and staff, is that part of deliberations or?
That should occur during the public hearing. Yeah, because anytime you're sort of gathering factual information, you want all that to be in the record of the hearing itself. Yep. So then once you close the hearing and you deliberate, then you all will make a decision and vote. And because it's a land use process, we have to actually have very specific written findings to address all the applicable criteria. And so in that situation, there may be times where it's a simple application where staff will have something prepared for you where they think, okay, this isn't controversial. We sort of know how it's going to play out, and you can vote on it that night. Or in a lot of situations, it'll be that staff will have to come back at your next meeting. They'll basically take the information that you just talked about. They'll go back and write all the findings, and then they'll bring it back to you for your next meeting to vote on for the final decision. Okay, so ex parte communications, what is that and why does it matter? So an ex parte communication is basically any communication that can be written, oral, or electronic that is made to you all as the decision makers concerning the subject matter of the quasi-judicial hearing, in most situations, a land use hearing, and it occurs while the matter is pending. So a matter is pending for land use purposes after the formal application has been accepted, it's been submitted and accepted, and then before the final decision is made. So somewhere in between that time period, an ex parte communication has to occur. Now, you may recall that recently you all may have been asked to have a meeting with some developers who want to talk about a potential project in the future. Because they had not submitted a land use application for that yet, it wasn't yet an ex parte communication. So you only have to remember that it's an ex parte communication during that time period. Yeah.
So when we're in that time period, if we get emails to all of council regarding this, then do we all have to say we had ex parte communications?
No, so in that situation, really the best thing to do would be to have that email submitted into the record. So
Oh.
with staff, hopefully staff would be copied on that, or if not, you would forward that to staff, and then staff would actually include that in the record itself.
Okay.
This is probably the most challenging part because we are being reached out to. We want to meet. I want to meet.
Yeah.
Part of being in council and running to this position, knocking on doors, talking to people, we run for certain reasons. I want to meet with people. I want to talk to both sides, but here we cannot. Why?
It relates to due process. And so let me just fast forward real quick here to how do you cure ex parte communications? Because it's not, if you meet with them, you're allowed to meet with them, but you have to just sort of disclose what was discussed, so everyone else can sort of respond to what was discussed. And the reasoning behind this rule is to ensure a fair hearing. Because if you're meeting with someone who I'm in opposition to, and they're giving you all this information and you're basing your decision off of that information, but I don't know what that information is, I don't really have an adequate opportunity to explain to you why what they're telling you may be wrong. So the idea is that you need to base your decision on the information that's presented at the hearing, where everyone has an opportunity to have that back and forth with each of you. So you, as an impartial decision maker, can say, okay, I've heard all the information. I've heard the arguments from both sides, not just one side, but from both sides. And based on that, here's the decision that I'm making. So if you have an ex parte communication, you can cure it. But what you have to do is before the hearing, you have to announce the fact that you had the ex parte communication, and you have to explain the substance of that communication in enough detail so that other people who weren't part of that discussion or communication can respond. And so the problem is, and why we really tell you to avoid ex parte communications, especially if you have too many of them, it gets really difficult to do. And even if you just have one or two, you have to really make sure that you've taken notes or have a good enough memory to be able to really explain the substance of that communication so the rest of the people participating in the process can respond to that. And if you don't, then that can invalidate the decision, because the courts and the Land Use Board of Appeals, which is the appellate body that hears land use appeals, will basically remand the decision and say that you violated the procedural rights of the other parties involved. And so that's sort of that due process and procedure and sort of that fair hearing is why we have to do these things. Now, again, this only applies to quasi-judicial. So if you go back to that legislative and you're creating the criteria in the first place and saying, here's what the rules should be, you can talk to as many people as you want and you don't have to report any of that. You sort of prejudge the decision, you can make up your mind, you can say, you can advocate for it, you can do all those sorts of things in the legislative process. But when you have this quasi-judicial process, these due process rights attached, and you really have to be careful about these kinds of things.
That's good clarification. So I would have to make sure we know before applications are submitted so that
Yeah.
we can have this open conversation.
Yep. Yes.
Yeah, please. So I'm part of the architectural review board, new
Okay.
to that committee. So I just want to, some of the language when we meet, asks, does any member of the audience, in part of the disclosure part, does any member of the audience wish to challenge any review board members' impartiality? So that could happen here in this setting then as well. Yes.
Yep, and we'll talk about that when I get to
Oh, I'm-
bias. No,
oh.
that's totally fine. That's more of a bias, but even with ex parte communications, people can challenge your participation to say, I don't think you truly revealed everything that was discussed, and sort of challenge, have you provided enough disclosure for me to be able to respond? But with bias, absolutely, as we'll talk about in a minute, we do need to provide them with an opportunity to challenge your impartiality, especially if you've got some sort of bias that you're disclosing, but you're saying it's not going to affect your ability to make the decision.
And so you'll talk about
Yep.
abstentions and such as well then.
Absolutely.
Thank you.
Yep. Okay, so and with ex parte communications, generally communications with staff are not deemed ex parte communications. There are exceptions to that rule, of course, but staff will, is well versed in that and they'll be able to walk you through that. And likewise with the city attorney are not ex parte communications. Communications with the party or their attorney are ex parte communications. So a lot of people think, oh, well, I was talking to their attorney, that was fine. that's still an ex parte communication. It doesn't matter if it's the attorney or the party themselves. Site visits, if you go on your own, you just go drive by the site and take a look at it, you need to disclose that. That's deemed an ex parte communication. Other outside information, such as social media posts, newspaper articles, also can be ex parte communications if they urge a result or provide information that you're going to rely on to make your decision.
Driving by this by myself, I still have to communicate it.
Yep.
Wow.
And it's real simple. Just say, I drove by the site. You'll see that a lot. The people say, I drove by the site, just take a look, you know, and
Right?
well, I think you can say, yeah, I think you can just say, I drive by that site as part of my commute every day, so I'm very familiar with it. Yeah, and that's, you know, and that's really the most common type of disclosure that we see with ex parte communications. Communications with audience members during a recess about the substance of a hearing can be an ex parte communication. So a lot of times these land use hearings go on for a long time, and you may take a bathroom break or you may continue it to the next meeting. If you're on break, you know, going to the bathroom and someone stops you on your way out and they say something to you, that could have been an ex parte communication. So when you come back and you start the hearing back up, you need to disclose that you just had this conversation with someone. Communications after a vote, but before the final written decision issue could also be an ex parte communication. So remember, I was just saying there's times in complicated matters where the staff hasn't written all the findings in advance. So they're going to come back to you after you vote. So you vote tonight, staff goes back, we write the findings, and then we bring it back to you at your next meeting in 2 weeks. If you have conversations with individuals in that 2 week time period, those can be ex parte communications, and you're going to want to sort of disclose that before you take your final vote on the final recommendations. Then the tricky one, and you know, this is, to me, this one's a bit controversial, but most land use lawyers advocate for this, so I put it in here, is that LUBA, again, which is the Land Use Board of Appeals, is the appellate body that these decisions go to. And there's times where LUBA will remand a decision back to the city, especially if there was a procedural error. And so if you have communications with individuals about a topic while something's pending at LUBA and it gets sent back to you, most land use lawyers will advise you to disclose those communications at the next hearing just to be safe. I'm not 100% convinced that those are in fact ex parte communications, but you know, as lawyers, we tell you to be as safe as possible, and you don't want to get remanded a second time just because you didn't disclose that. So even after you've made your decision, you may want to sort of keep track of what communications you have with people complaining to you about your decision, if just in case it comes back to you.
Do you have a simple phrase we could use, because people will want to talk to us about these things and you have to shut them down. And say,
Yeah.
I can't discuss this. So do you have a simple phrase or term or that we could use?
Yeah, what I try to tell people is to protect the fairness of the process for everyone involved. I really can't talk about these issues until the final decision and the appeal process is done. After that, I'm happy to sit down with you. I'm happy to talk to you. But until that final appeal process is over, it's just not, you know, I have to protect the fairness of the process. And then you can blame the lawyers and the Constitution. Okay, we talked about curing ex parte contacts, and the idea is that people have a right to be heard, they have a right to an impartial tribunal, and the right to present and rebut evidence. That's why we have to do these things. And if we don't adequately disclose them, it is a basis for LUBA to sort of remand and overturn a decision. So that's why it's really important that we focus on that. Okay, so bias. Bias is the second one. Remember, it's ex parte contacts, bias, and conflicts of interest. Bias is sort of what you all understand bias to be. It's basically that as to protect the due process rights of the parties involved, you have to be impartial when you're making your decision. You have to base your decision on the record that's presented to you. You can't prejudge an issue. So if you have such strong feelings, whether it's about the matter being presented, whether it's about one of the parties involved, or whether you've got a personal interest in the decision, you know, that, you know, it's right next door to your house and that's going to either affect your property values positively or negatively. Those are the kinds of situations where you've got a bias that is so strong that you may not be able to participate. A bias isn't, you know, something that's just because you've made a statement on the campaign trail or you've generally got a feeling about something doesn't rise to the level of bias. You have to have concrete statements where you're really opposed to something. So an example of this is out in Hood River. When you're driving along 84, there's a big Walmart right by the highway. So before that was built, there was a member of the public who was sort of the head of the anti-Walmart group. And they were like, we don't want Walmart in our community. They led that organization. They had a whole organization for it. That person later got on, I can't remember if it's the city council or the county commission, when the Walmart application was going before them. And they said, well, I'm not biased, I can participate. And they were like, well, no, you were literally the head of the organization. So that's the kind of like level of stuff that we're talking about. Like you've taken such a strong position on an issue that there's no way that you can't be, that there's no way you can be impartial. Another common example is that we've run into, especially in smaller towns, is the applicant's your best friend that you've known for 40 years. And, you do all the holidays with them and everything else like that. It's not really reasonable to expect that you're going to, not be biased towards that person. Because again, the bias can be both negative and positive. It doesn't mean that you have to be against it. It could be that you're so in favor of it that you're not really able to be impartial. So you got to think about it in those situations. For bias, even if it's an issue that you think you can be impartial, but you think there's, something that the public would want to know about. So, an example that we've had in other jurisdictions is one of the members of the city council was a retired lawyer. And the retired lawyer, he would have applicants come before the city council every now and then that used to be his clients. So he would always disclose on the record that when I practiced law, this person was a client of mine. I haven't worked with them for 15 years. I think I can be impartial. It's not going to influence my ability to participate in this decision. But he would always disclose that on the record. And then that would give people the opportunity, as you were talking about, to challenge the decision and challenge the impartiality of the individual participating in the process. And it's really important to do that because once you've done that, and we provide an opportunity for people to challenge the impartiality of anyone participating, if no one raises that issue then they likely waive their ability to make that argument down the road, whether it's an appeal to LUBA in the courts or otherwise. If they didn't raise the issue with you now, then they don't really get to go later on and say you were impartial. Unless, of course, you take actions during the hearing itself that really demonstrate your bias, then that, is always a factor that would change that. But, it's better to sort of get that information out on the record so everyone sort of understands, okay, here's what the person's saying. They're telling me they can be impartial. Then I, as a participant in the process, can say, yeah, I agree with you or I disagree with you and say, oh, it's time for you to sort of step and challenge your ability to participate. Does that make sense? Okay. So conflicts of interest. Conflicts of interest are actually defined by state law. And so a conflict of interest basically is any decision that could have a financial impact on you, your relatives, or businesses with which they are associated. And there are two kinds of conflicts of interest, potential and actual. And the difference between them are the words would and could. Here's mine, I know. So actual conflict of interest is when a decision would have an impact on you, your relatives, or businesses with which any of those are associated. Potential is when it could have. So a good example of this that I always like to talk to people about is, let's say for some reason, before the city issues a request for proposals on a contract for a towing company to tow cars for the city, that we've got to bring that to the city council for approval. And so we come to you and we say, we'd like your authorization to issue this RFP. And you say, well, you know what? My brother owns a garage that tows cars. He could apply for this contract. So that's a potential conflict for me. So when I'm voting to approve this RFP, I have to declare a potential conflict of interest. When you have a potential conflict of interest, you have to make a declaration of your potential conflict, and then you're actually allowed to participate in the underlying discussion and vote. The disclosure that you make has to be of enough substance so people understand the nature of the conflict. So you can't just say, I have a potential conflict in this RFP. I'd say, I have a potential conflict in this RFP because my brother owns a garage that provides towing services and he could apply for the contract. So you need that level of detail in making that disclosure. So let's say in that example, then we issue the RFP. Your brother does in fact apply for the contract. He's the best bidder and we're going to award the contract to him. And we bring that contract back to you for approval. In that situation, the decision to award the contract to your brother would have a financial impact on him because he's going to get money from his contract. So that would be an actual conflict of interest. Again, the difference is would and could. With the would situation, you have to make that same disclosure, but then you have to abstain from participating in the entire process, which includes both the discussion and the vote itself. It is not legally required, but I always recommend in those situations, whether it's you're recusing yourself because of a bias, because of too many ex parte contacts, or because of conflict of interest, that you actually get up from the table and you sort of go sit in the back of the room when the discussion's occurring. And again, it's not legally required, but none of us have a perfect poker face where we're going to be able to sit like without any emotion whatsoever. And you may be getting a text from, your kids or your significant other or whomever about something that you're excited about, or you may look at the Blazers score and see that they're losing again, and you may get a really disgusted look on your face, whatever the case might be. But, the people watching on Zoom and seeing that, they don't know what you're doing. And they may say, look, he's making faces. He's trying to influence what they're talking about. And so it's just better that if you go to the back of the room, you're never putting yourself in that position to have people question what you're doing when you've got that conflict of interest, or recuse yourself because of bias or too many ex parte communications. Okay, so in your materials, we talk about relatives and what is a business. And there are some exceptions. And all of this is probably, been explained to you in much greater detail in trainings, much more about conflicts of interest. But if you do ever have a question, and, again, the key here is not to say, oh, I know how to handle the situation, but to come ask staff. We can work with the Ethics Commission. They can work with our office. And they can really help you through that process and try to do it as early in the process as possible. So we're not trying to make decisions at the last minute. If you ask me tonight, is this a conflict of interest for a hearing tonight? I'm probably going to be conservative and tell you, yeah, abstain from participating. We don't want to risk it. But if you really want to participate, you want to make sure that you give us time to deal with that. Okay, there's a little bit on the materials about control of public meetings. The key thing there to remember is that if you have a very disruptive meeting, that you need to make sure that we're providing warnings to people and then we're getting that recorded. So we're telling people you're disrupting the meeting, you're not allowing us to have our meeting. And we make sure before we actually try to kick them out that we've gone through that process and really provided them the warnings and told them why their behavior is disrupting the meeting. So that way we can remove them from the meeting without violating their constitutional rights.
And is it just like one warning necessary, or is there some?
We need at least one warning. It really depends on the circumstances. And if it's a whole group of people making a lot of noise, then, just providing one warning to one person probably isn't enough. You really want to make sure that people are getting individualized notice that my specific behavior is hurting the ability for the council to do its job.
Is there a time where you say, okay, this needs to be postponed because there's just too much going on?
Yep. Yeah, if in fact there's a whole lot of people causing disruptions, that's the better course of action instead of trying to pick individuals to remove. Yeah. Or we're ending this meeting. Next one's just going to be fully online on Zoom, so you can really control that participation and have everyone muted so they can't interrupt your discussions. Okay, the last thing I want to talk about in a couple minutes we have left are public records. Public records, for the most part, are going to be handled by staff, but you all will receive public records in the course of your official duties, or you may even create public records in the course of your official duties. And it's important for you to understand two things. One is that the public records law, if we receive a public records request, requires disclosure of those records unless a specific exemption exists that allows us to keep this confidential. And two, the public records laws require us to retain records for a certain period of time before we're allowed to destroy them. If you destroy those records, not in accordance with the record retention policy, that can actually be deemed a crime under state law. And not that I've ever seen, I can think of one situation, I think, where a staff member destroyed a whole bunch of public records. But other than that, I've never seen an elected official actually charged by a district attorney, but I don't want you to be the first case that I know of. So we want to make sure that you're not destroying public records. So real quick about public records, the city is required to keep one official copy of the record. So to the extent that you get a document from the city, but the city already has that exact same copy of the record, you can recycle yours, throw it away, do whatever you want with it, because the city will already have kept that record. However, and this is the big however, if you start making notes on that, then you've created a new public record. And so now we need to keep that one with your notes on. So to the extent that you want to keep notes, exactly what you're doing there, I really advise folks to have a separate notebook where you're keeping your notes, so it's all in one place and you just have to worry about keeping that notebook. Or some people do it electronically where they're taking notes on a computer and you keep those files, that's fine. But really make sure that you're not creating new public records that then you have to make sure that you're keeping. You want to make sure that whatever you've got, the city already has a copy of, And so therefore you don't have to worry about retaining yours. That's the safest and easiest thing for you all to do. So that also applies to, not that we've received a lot of these, but if you get a letter from a constituent, actually like, a handwritten or typewritten letter, that's a public record. So you want to make sure that the city gets a copy of that, or that you need to make sure that you're retaining it. Same thing with emails. If it's not on the city's email system, whether it's automatically being backed up, someone has your personal email for some reason or whatever, make sure you forward that to your city email account and respond from your city email account. So that way all that stuff is backed up for you. You don't have to worry about retaining all that. Because the potential consequences are that if you have a whole bunch of public records and you're not following this process, and we get a public records request and someone challenges whether or not we've complied, or we get in litigation for some reason, there's discovery request for your documents, the court may order that your personal devices be searched. So that could be your home computers, your home laptops, your phones, whatever the case might be. The court could allow the other side to have experts go through that and see what you've got on your devices to see if you've disclosed everything. So, but if you have a process in place and you're following that process, it's much less likely that the court will actually order that to happen. And, it hasn't happened often, but it has happened in a couple of situations, both in Lane County and over in Beaverton. It happened, about a decade and a half ago in some litigation they had with Nike. So you just want to be very careful about how you're treating those public records. Make sure you have a process to keep those records retained, and that the city has the ability to then provide those records to the extent we get a public records request for. Any questions about that? All right, we are about 1 minute over. I threw a lot of information at you. Again, the goal is just to be able to recognize issues. Like hopefully, some of this sticks with you, and to the extent that you have questions or, there's an issue, talk to Sherilyn. You can always talk to our office as well. We're here to support you. You've got amazing staff here in the city, and they're really, really knowledgeable. And so rely on them. That's why they're here. So with that, I'll answer any more questions you have, and I'll remain available. I'll be here the rest of the night.
More questions for Chad?
Well, thank you all for staying awake. That's the biggest hurdle.
That brings us to item number 2, an update on the Basalt Creek Employment Zone project. Aaron, and hello, Steve.
Yep.
You gotta let it.
Right, are we ready to begin?
Let's do it.
Okay. Good evening, Mayor and City Councilors. My name is Erin Ingman, and I'm the Senior Planner with the City of Tualatin. And tonight I am joined by our Assistant Community Development Director, Steve Coper, and our HHPR consultant team of Chris Green and Brad Kilby, who are joining us remotely to provide an update on the Basalt Creek Employment Zone project. If my slides will advance. Okay. So for tonight's discussion, we will cover the project's background and purpose, our public outreach efforts, and what we've learned. We'll also have a brief summary of our code scenarios that were shared with the Planning Commission and their recommendation to council. And then we'll wrap it up with next steps. And on this next slide, I'm going to turn it over to Chris, who is remote on Zoom, to talk about our sub-consultants and our project scope.
Yeah, thank you, Erin. So our scope for this project, we had 4 kind of main components. 3 of those kind of went into the background. So Harper Hoff Peterson Regelis, or HHPR, we're a multidisciplinary firm. We do civil engineering work, planning, landscape architecture, and we have a lot of experience with public sector clients, both through our firm, and then both Brad Kilby and I, who are on the call, have quite a bit of experience in the public sector, implementing development codes and seeing kind of what works and what doesn't from both sides of that table. So we took a look at that existing manufacturing park zone and kind of what was how it could be implemented, how it was being implemented. We had economic analysis with Leland Consulting Group, so looking at market conditions in the southwest part of the metropolitan area, what the state of industrial development is, and kind of looking at how that would apply in this zone. So Leland has a very long history, over 30 years in the local area of economic, land use, and development feasibility analysis. DKS Associates worked on transportation planning rule analysis and looking at trip generation and what potential impacts would be from different scenarios in terms of uses that were allowed in the zone. So DKS has lots of experience with any of the jurisdictions in this part of the metro area. They have transportation engineers and planners that looked at that. And then as the project team, we put together the draft code amendments. Next slide. So the project area is a smaller part of the overall Basalt Creek area. So there was the concept plan that was adopted a few years back that looked at 847 acres, some of them in Tualatin and some in Wilsonville. This project is specifically looking at the manufacturing park zone within that Basalt Creek area. So that's 156 acres, still a large area, but a smaller piece of it. And you can see it's along both sides of Graham's Ferry Road. The Basalt Creek Parkway forms the south boundary, and it goes up to Tonkin Loop. Next slide. So there are some constraints for industrial development there, not for necessarily insurmountable, but some things that make it a little more complicated topography. There's some areas, especially east of Graham's Ferry, that have over 10% slopes, and industrial development, especially larger footprint industrial development, really it needs pretty flat ground. There's a variety of parcel sizes. So there's some larger holdings where there's multiple parcels that are owned in common. But a lot of those are in the 5 to 10 acre range. But there are some below 5 acre parcels through there. So, it's not necessarily an area where it's A, flat, and B, like 100 acres of single property just sitting there. And then the big one, and Erin will talk a little bit about the plans that have been made for this area, but infrastructure needs. So connecting water and sewer to this area is pretty key for industrial development or any type of development that's planned there. And so that ends up being paid for in part by directly through development activity, but also there's tax increment finance district for this area, so that becomes sort of a chicken and egg in terms of paying for that infrastructure as development comes in. Next slide. So in our code audit, we looked at the existing manufacturing park zone. And it was definitely a zone that was intended for a very specific type of manufacturing and research activity at a very specific time and pretty large scale. It says here, you know, limited light industrial uses. There was specifically a list of in that zone of what those uses are that are allowed, and so that's something that you'll see in recommendations later on, is kind of opening that up to not just an exclusive list, but more of a type of uses, and then a lot of requirements for landscaping and setbacks. It talks about park or campus like grounds, and then distribution and warehousing is not permitted within that zone. I think that the next slide.
Okay, so this project is building on a decade of previous planning work that culminated in adopted plans such as the Basalt Creek Concept Plan, the Economic Opportunities Analysis in the Southwest and Basalt Urban Renewal Area. These documents inform the project aspirations, which include encouraging employment dense development while strengthening the local tax base and minimizing conflicts with nearby residential land. Staff held a work session with council last spring to introduce the project and our preliminary findings from the economic analysis and code audit work. Council then directed staff to continue work on this legislative amendment with the following feedback: to limit uses and corresponding truck traffic, particularly on Boones Ferry Road, encourage flexible multi-tenant, multi-use development, incorporate neighborhood commercial uses, and maintain green space or trail connectivity for employees to enjoy. There's been extensive public outreach opportunities throughout this project, where staff has engaged in an open house with the public. We had some stakeholders attend that meeting, and then some nearby cities and counties participated as well to share some feedback and just kind of hear about the project. And you'll see there's been multiple opportunities to discuss this project with stakeholders, citizen involvement organizations, and the business groups at large. And we've learned a great deal since our last presentation to council. And if you are interested, a summary of this work is included as Exhibit 4. The public, particularly the Byram CEOs, have shared general concerns over traffic, noise, and pollution. They support requiring all operations within a completely enclosed building, landscape buffering standards adjacent to the nearby residential zone, permitting uses that bring high-wage jobs, as well as commercial benefits to nearby residents and workers. Next slide, please. And then on this side, we see the industrial stakeholders have also provided feedback, which is echoed in our economic analysis report. And they have shared that flexible tenant space, sometimes referred to as spec development, has replaced owner-occupied, purpose-built development in the market. Tenant development requires flexible regulation to secure capital for construction and to maintain consistent occupancy. And that many industrial tenants require a warehousing and/or wholesale sales component to supplement or support their operations. Next slide. Through the course of the project, the stakeholders have shared that our initial draft code was too aspirational and didn't provide sufficient flexibility to support the market. So in response, staff prepared various code scenarios for the Planning Commission to consider. And these code scenarios attempted to balance the previously expressed aspirations for the area with current market trends. And the scenarios range from highly aspirational and potentially restrictive to providing greater regulatory flexibility while ensuring some level of desired development. And now I'll turn it back over to Chris to discuss our findings.
Yeah, so some of those findings and current market conditions that Aaron mentioned that were taken into account were from the economic analysis that Leland Consulting did. They looked at the Southwest submarket, so Tualatin and some of the surrounding cities, which is typically about a quarter of the industrial development that takes place in the metro area. And basically, in short, there's a shortage of industrial space that's available. At the time of their study, which was last June, there was 3.7% vacancy for industrial space, and the price per square foot had doubled in the past decade. And then the type of industrial spaces that users were looking for, more multi-tenant spaces that could be divided into smaller uses. The study also talked about some jurisdictions have had success with allowing a wider range of uses, but looking at if they wanted smaller footprint buildings, actually having that in the zoning code itself rather than just looking at uses. Next slide. So the recommendations that came out of that economic analysis, expanding the types of industrial uses that were allowed. So I talked a little bit about that, not just having a short list of what's allowed and everything else isn't, but looking at different types of industrial uses and industrial commercial distribution kind of hybrids within the same firm a lot of the time. So flexibility is really important, and as business needs change pretty rapidly, code that's too prescriptive can lose track of that really quickly. And then looking at, especially adjacent to residential areas, having standards to kind of address some of those issues in specific areas rather than having just really large landscaped areas, regardless of the context. Next slide. And then to summarize the traffic analysis that DKS did. So the state looks at reasonable worst case trip generation from what the allowed uses are in a certain area currently versus in the future. So in comparing the kind of two sets of uses from the status quo to different scenarios, there was actually a slight reduction in the expected trips to be generated. There's a small expansion of commercial uses in this code just because the previous manufacturing park zone applied kind of an older restriction that Metro had on amount of commercial space. This loosens that up a bit to meet the current standard, but even then the warehousing and industrial park type use mix actually has slightly fewer trips than just pure manufacturing, which is pretty intensive in terms of trips. Next slide.
Thank you. I'm going to take this slide. Unfortunately, our outgoing economic development manager, Jonathan Taylor, would have taken this, but I'm going to sub in for him and give a little bit of information to the council about how this project is connected to the Southwest and Basalt Creek development area, also known as urban renewal. And so as it's been stated previously in the presentation, the goal of this project is to change the development code to allow uses that support quality development and job dense employment. The code project aims to meet these goals while incorporating feedback from the development and business community, which will support build out of the area as well as provide future jobs. The code project also aims to meet the feedback from the public, and last but not least, council goals and priorities. One additional important consideration in assessing the future success of this code is whether or not it will result in development that meets market needs, particularly of businesses that want to expand or relocate to Tualatin. In addition, the ability of near-term development to act as a catalyst to both kickstart the construction of needed public infrastructure in this area, as well as the ability of that development to generate tax increment early in the timeline of the urban renewal district, will help increase the chances that the urban renewal district successfully meets its objectives. And with that, is our planning commission chair Bill Beers online? Sorry, council, I thought he was going to be here in person. Is he on? No. Okay, well, I'll do my best to give planning commission recommendation in his absence. Next slide, please. So the planning commission's direction at its meeting on January 19th was consistent with the stakeholder feedback as well as our economic analysis to allow a variety of manufacturing uses, those that are both considered heavy and light. Additional little context into that recommendation was based on feedback from our economic development manager and other feedback that basically concluded that any manufacturing, whether or not it was heavy or light, is considered advanced manufacturing at this point in time. And so our code's division of those two is a little bit outdated. The second part of the recommendation was for staff to develop some level of design standards to create a pleasant street facing environment and basically overall aesthetically pleasing district. The third of which ties into some of the public feedback that Aaron went through, is through the use of landscaping and then actual physical setback buffers to buffer this district where it interfaces with residential lands to the north. And then the last of which is to comply with our existing Chapter 63 environmental standards that apply to industrial development, which protect the protect the public from impacts from the property's noise, glare, odors, vibration, and dust. And that also ties in with the directive to have the uses enclosed within buildings as well. Next slide, please. And so the Planning Commission also heard the stakeholder C scenario, which you have letters of support from stakeholders themselves represented by the Schnitzer Group, as well as from the Westside Economic Alliance and our own Tualatin Chamber of Commerce. And so that scenario basically adds some additional flexibility to what the Planning Commission also recommended. It caps maximum building size at 150,000 square feet to limit large format distribution uses. I think we all know what they're called, but I won't say their names here. It also requires at least 30% of building square footage on a site to be manufacturing uses, and so that's in line with the original goals of this project and the previously adopted documents. And then that would allow the remaining 70% of building square footage on a site to be a flex space combination of warehousing and distribution and or wholesale uses. Obviously, it could also be any other allowed uses in that zone. But the stakeholder group sought flexibility to include those uses specifically. And then again, in line and consistent with previous recommendations, all uses would be fully enclosed except for, of course, parking and loading areas. And then next slide, please. And so on that second piece, the Planning Commission is requesting council feedback. As I mentioned on the previous slide, the Planning Commission found that scenario C supports the original goals of the previously adopted documents. However, I think they had some concern that it might be construed as being different than the council's previous direction at its May work session of 2022. And so they were interested in checking in with the council to make sure that they're finding that this scenario, which they ostensibly supported, was still in line with the council's original direction, or I guess I would say original direction as modified by the information that we presented to you tonight as well as some of the other stakeholder and other support that you've also received. And then next slide, I'll turn it back over to Erin to talk about next steps for the project.
So with these next steps, staff anticipates returning to the Planning Commission in March to summarize our discussion with you tonight and seek a final recommendation from the Planning Commission. And then if they are able to make that final recommendation or come to that conclusion, staff will return to council. We're thinking in early summer to share the proposed text and map amendment of the project and potentially close our legislative hearing and culminate in an adopted ordinance. With that, I guess I'll open it up for any questions that you may have of staff or on the project.
My question.
That's correct.
Number one, I don't want me to put you on the spot, but could you give an example of a building that would be about 150,000 square feet? That's a pretty good sized warehouse or building. So is there some fairly close or something, a fraction of that size, just to give us a visualization?
Maybe a large format Fred Meyer or
Okay.
I think we're thinking also on the new buildings under construction under Herman Road are probably around that threshold.
Oh, okay. And then on the scenario C, it says that I'm looking at wholesale sales. I think they're both the same. So this may not exceed 35% of total building square footage on the site. So if they had multiple buildings on a site, could one building, if that's 35% or less of the total buildings on 10 acres, that building be all just warehousing?
It could be, but then the 150,000, so that's the intention of the 150,000 square feet is that even if you build a lot of square footage, like a distribution, like isn't going to be able to succeed in a 150,000 square foot building. So it'll work for small format uses that have warehousing as a component. And it could even be the sole tenant of that building, right?
Okay. And then back on your he was talking about the trip generation. I'm really confused. Decrease compared to what?
Compared to basically what the existing zone allows. And so the analysis takes the existing zone's allowance because both in the interest of knowing the answer, but also legally required, but understanding what the changes to the zoning would affect as far as projected trip generation for the zone. And so generally speaking, per square foot, warehousing and distribution has a lower trip generation rate than, as well as wholesale sales than manufacturing, particularly since the manufacturing uses that we allowed in this existing zone were very limited. And so by opening more manufacturing uses that comprise a broader spectrum of prospective future uses and incorporating more of the flexibility into it, the reasonable worst case scenario actually decreases.
Okay. Then one of my concerns here, and I don't know which way it plays out better, but we really wanted to have, let's say, livable wages and higher wage jobs. And it was stated that there's a high demand for these type of spaces. So would this scenario C, as opposed to the original A, maybe you can't speak to this, but would that help with that? Or, because I think of like big warehouses, and I know we're limiting them, but I want to make sure this is helping to provide that type of jobs and that we're not putting robotic things in there where we're going to have 2 employees.
Yeah, it's a hard one to answer. I mean, I'll give a couple of different answers and see if it gets to where you're going, and then let me know if I have not met it. I mean, the first of which is that through zoning, it's hard to kind of actually, figure out. It's hard for us to, by excluding uses, actually make other uses happen in a space. That requires, a lot of other things to align. It requires a lot of other investment to happen, which is not really something that is part of this project. I think the other piece of it is that, and our stakeholder group actually conducted a smaller economic analysis specifically aimed at that question, which is within the packet materials. And basically kind of the long and the short of that is that as automation has entered the workforce, manufacturing jobs have generally declined somewhat in wages and also gotten less job dense. And then conversely, warehousing type of jobs, particularly because they're often attached to another use, have on the whole increased in their job density and also increased in wages to the point where they're kind of meeting each other in the middle. And so that's less of a concern. I know when Aaron and I started out in the project, we looked at like a list of different wages for different manufacturing types. And there is variation is the other piece. And so you can't, I mean, even if you allow manufacturing broadly, you may or may not be able to, independent of doing some other action to attract a specific business or industry, you may not end up with that outcome anyway.
Okay, and then, I believe, do these scenarios have different, I know it does, but I can't remember where, but it reduces the landscaping in some of these scenarios, necessary, and, I guess my big concern is that we're looking at putting residential along one side of this. And how would it make any difference in these different scenarios, how we're protecting and making sure that it's livable and, we don't have the noise and other smell, other environmental things affecting that neighborhood?
So yeah, so a couple of things, one of which is as you mentioned, the requirement that uses are conducted indoors. We also have within our development code, and we didn't want to get into this level of detail necessarily, but there's also like wing wall, they're called requirements, where if a business has like a roll-up door that faces the residential area, that they have to build an additional sound buffer, basically independent of
Okay,
the buffering. But basically the MP zone itself doesn't have a specific buffering requirement from residential areas. And so that's something that this code will actually add in. The overall percentage of landscaping is being reduced slightly, mainly because of what Chris mentioned in his presentation. The parcel sizes are smaller. And so because it's harder to get that large campus, it's harder to get an overall total percentage as high. The MP zone had an exceptionally high percentage of 25%. And so I think the current draft of the code has it at 20%, which is still higher than any of our other industrial zones. But the buffering requirements are basically increased owing to the fact that there's residential area there. So there's basically setbacks, buffering, landscape requirement, and then there's a reduction in building height for buildings that are adjacent to the residential area additionally.
and I guess with that, the whole like the 20% I get, but then what happens to all that land that's at 10% or higher grade? I mean, you can't build anything on that, right? What? Oh, you just blast it and that's it.
Yeah, that'll be interesting. That'll be interesting to see. Yes. I
Okay.
mean, some of that it'll have to be, retaining walls and grading. Yes.
Thank you.
You're welcome.
I apologize, I didn't look this up before, but will you please speak to, in this proposed zoning area, the number of marijuana grows and dispensaries that will be allowed?
I think when we were looking at our regulation within chapter 80, we have found that this area would just be excluded based off our buffering standards. So essentially this zone would not be eligible for cannabis facilities.
And what about psilocybin currently?
I don't know if Steve wants to chime in, but I believe our psilocybin is going to kind of mirror what we have for cannabis, or we're potentially drafting it for council consideration.
But as of today, it would be allowed.
I think it has to be the 1,000 feet.
I don't know the answer to that question. I'll have to get back to you on that. They're a little bit differently because they're not retail facilities, and so they're effectively treated like medical clinics. And so I don't know how those pieces all fit together. And so I'm sorry, I'll have to get back to you.
Yeah, no, thank you very much. I just clarifying that there could not be necessarily a grow and then a retail space in the front. And you're saying, you answered that question, so thank
For
you.
marijuana, yes.
Thank you.
What questions?
Thanks for your presentation. So just to kind of go back a little bit, we are making changes from last year based on economic changes that have just happened.
So I think that the kind of chronology of the project was that, we understood that the existing zone was very limiting in its uses. We also understood that the council, particularly urban renewal, is a good example of it, as well as previous aspirations, had an interest in seeing, I think, a high quality, robust development of this area. And so we recognized that the existing code was unlikely to facilitate that based on economic conditions that had probably existed for quite some time at this point. And so we didn't have necessarily a ton of background information. We hadn't also done nearly as much public outreach as we'd done to date. And so where we are now is that the council, I think we heard, essentially that they agreed with the previous aspirations of the plans. They understood kind of our preliminary economic analysis, but now that we've gotten more detailed with our economic analysis and actually gotten to have a number of conversations with our stakeholders, particularly stakeholders that are engaged in the business of developing ground, and kind of understanding what the, I think, limitations on being able to support development are for the area, we've come to you with a change to the original direction that still meets, I think, the original objectives of it, but is a different, perhaps, outcome than the original expectation. And so we're here to check in with you to see if the idea of meeting the original goals with a different outcome that also is supported by a number of other groups that are engaged in developing and then populating the future development with employees is amenable to the council.
Yeah, when I look over the information, the biggest things that stand out to me and my concerns are good paying jobs. And part of that has to do with not just having that goal maintained. I think that it's interesting because I don't like ever going to less aspirational goals in a certain way. And I think that's part of why having these comprehensive plans are so important. So, and especially because market conditions are very, with the way the interest rates are right now, and things are very specifically dynamic after COVID. So those are the biggest concerns for me, are those maintaining that goal of good paying jobs, having places that people that live here can work, and to reduce those. It's not just about warehouse traffic and trucks. It's also about trips across town, that east-west corridor that we talk about so often. That's very difficult and is created, well, everybody knows, a traffic issue. And then I appreciate also where we're at with traffic studies, and have apprehension due to, the tolling coming and some other things that are going to cause problems in Boone's Ferry. So that, and then the maintaining the park like back, the trails still stay in place, and really being mindful of trees. I think right now for our community, and just when we see snow in California, and things that nobody's seen in their lifetime, that being really mindful is, we want this to be successful, and but cheap build outs with low paying jobs that we don't always fill right in our core downtown, located on the other side of a canyon that people are really concerned about, isn't what I find something I'm except, that I think the community is really excited about, or that was about our plans. So those are my concerns. And then I think I also, looking at the plan from whenever it was drafted, what are the needs as well? So we look at what the market needs are, but what are the needs for jobs, for good paying jobs, and making sure that we kind of line up our community needs with it. Thank you very much.
Go ahead.
So when I was reading through, I was really unclear if you're gonna allow food carts or not in this whole area, because that would reduce trips, just having a place for people. I'm thinking more like for people to go have lunch.
We didn't,
At work.
we didn't provide you a copy of the draft code just because it's a little bit messy at this point, but that is a single food cart pod is listed as a permitted use in there. I think also to Counselor Brooks's points, one of the things that when we looked at doing the traffic study and the allowed uses that we looked at really carefully was when we looked at the commercial uses that were allowed by Metro, incorporating medical office, which is a higher trip generator, but we felt it really important to provide those opportunities for people who live in Tualatin to potentially be an employer and also just people who live in the nearby residential areas to go to a medical appointment and not have to go across town. We are limited by Metro on how much of those uses we can allow. We can't just turn the district into one that allows those, but that was something that we looked at very closely. And I know that's not really what we came to discuss tonight, but I think it is important to point that out, that we were, I think, pretty careful about trying to figure out. And that also doesn't, there's some ability to count what are called nearby trip reductions into your trips count. And we didn't necessarily take that into account when we did the trip generation. We just did it the straight way. And so that's another thing to think about, is that if those uses can get built, which is the balance of figuring out how to get development off the ground with the catalyst, and then having those other opportunities there. So I agree with both your comments.
No questions. I got a couple. So having been on council when we did the Basalt Creek concept plan, we were envisioning a LAM research, JAE, something like that going into that area. So are the people reading the tea leaves here tell me that's never going to happen? That spec buildings is what we're going to have for development for next 10 years?
Yeah, I mean, I'll say again, I wish Jonathan was here to help chime in, but he's not. So I'll do my best impression of him. Yeah, I mean, I think that's generally speaking true. And that I think that they've not expressed interest in expanding. I mean, LAM still has a ways to build out its campus as it is and is not in
I'm
general.
not saying specific LAM, I'm
Sure.
saying that kind of model, those types of jobs, that kind of manufacturing.
I mean, you
You
probably know, I mean, the way that like economic development works now with working through the state, and it's different than it was when all those businesses were cited here. And the council of that time took a much more active role in recruiting those businesses to come here. And the state has changed it so that, it all goes through them as a clearinghouse. And basically, you identify your different tier industrial sites that you have based on their readiness. And so of course, none of these are ready. And so none of them we don't even enter them into the contest of whether or not they would be developed in the future. And so the only way, I mean, is to have some sort of catalyst that, and again, we have a set of stakeholders that are interested in developing the very southeast corner of this, which from our infrastructure perspective of looping water and providing sewer gravity to the north, it's the very best place to start. And so if there's a chance that any of the remaining acreage, I mean, if we're talking about 50 acres for these stakeholders and there's, another 150 in the district, it's obviously the rest of it's parcelized. And so it's harder to do an assemblage, but I mean, there is a chance there still, but I think that without it becoming, a tier 1 shovel ready site, we're not going to be competitive. And so we we did talk a lot about that at the beginning of the project, but I think that's kind of where it stands.
And then turn head around the term job dense, because I guess what other counselors saying, job dense to me is, again, something like Lamb and JE, we have a lot of people inside the building working versus, as folks are mentioning, if it's a distribution warehousing, yes, it's not going to be 100% warehousing, but it doesn't seem to me that that's job dense. That's a handful of people. And as Council Brooks said, the aspiration was get job density there, and it was from Metro. The whole reason this land was brought in, the UGB from Metro and the Basalt Creek planning thing was all about jobs. And it doesn't seem we're hitting that aspiration that Metro wanted us to do. So I'm wondering, I'm assuming there's been communication with Metro. Is this something Metro's okay with? Because this land wasn't, brought in the UGB for this purpose.
I mean, so I guess a couple of things that, looking at Wilsonville's district directly to the south, I mean, that is going to be a where they're going to allow warehousing and distribution in it. Warehousing and distribution is a perfectly allowed industrial use. It's not subject to any limitations under Title IV. And so it's more so, I mean, there's a lot of valid reasons for our council to be, I think, slow, in wanting to have other, what are perceived as non-job dense forms of development. So I think, again, I guess referring back to the packet and the materials that you have economic analysis from the stakeholders who are interested in seeing this as part of the mix that provides information that it's not as, that it's more job dense than it previously was, and that it's considered generally, particularly the smaller format warehousing and distribution, because it's a different, I mean, it can be a matter of definitions, but I mean, it has more of a functional part of businesses. I mean, the same as the wholesale sales is that it's like all part of what businesses need to survive and thrive. I think, again, it comes down to this question of balance of like, the aspirations were in large part, done in a vacuum where it's like, we want this. And now we've gotten to the point where we're testing the wants with the ability to get it off the ground. And we're saying here, like, we're, carving out some requirement that manufacturing is part of a component on a site in order to meet those goals of job density, quality development, high assessed value development. But the give is that some ability of this is developed as other things. And of course, it's tenant space. And so it may transition and develop, it may be different tenants over a space in time. And I mean, Schnitzer has told us, and this, I mean, I'm sure they'll testify at the hearing, that if someone wants to be all manufacturing and they can lease the space to manufacture, they'll be happy to do so. They just, in order to obtain that financing from the bank, if it's too restrictive on the uses that can go in, the bank is going to view it skeptically. And you have other areas that are less flexible. Most of Tualatin is very flexible, which is in part why we have that low vacancy rate that was cited. And so, if the bank looks at it and says, well, this doesn't look like a mix of uses that is likely to result in a low vacancy rate, they're not going to lend money. And so there is obviously, and this is why the council is the decision makers and why we're here tonight, is, you get to decide where that balance falls. But I think that we've done our best to kind of accurately present all sides of information and leave it to you.
Well, my last question, is on the trips. And I know we'll probably get into this later, but is the high level theory that I'm trying to grasp is that since we're not doing like a JAE or another Lamb, that all these cars will be coming and going, there'd be less cars coming and going, but substitute with some trucks. Yeah, how do the trips counts go down?
It is a total trip count though.
Yeah.
And so, I mean, warehousing and distribution does have slightly less. I mean, again, at some point it is at the expense of job density, right? Like that it's not a perfect 1-for-1. I think it's just the point and the emphasis that's being made by the stakeholders and the other members of the economic community that are in support of the balance in particular that we presented, is that is basically that it results in a net reduction, right? That, I mean, it would be great to have exactly the same, or maybe even if we added some of the other uses like the food carts in the medical office, that state law, allows us to be basically within 400 or so total trips. And it's still considered like reasonably the same, like we could go over trips. But this basically represents a balance that is workable and is, per the parties involved that we've done our outreach to, likely to result in development. And so I think that's the other thing to consider is that, we've heard the planning commission was very vocal about wanting to like maintain or reduce trips. They didn't even want to go over into the 400 territory that we would have been allowed to do so. And so, I mean, that's kind of how we got there, is that we balanced a whole bunch of different things. And in order to get some of the things that we knew the council and the community wanted, we scaled back in other places. And so I don't know if that answers your question.
It does. And finally, because I know we're talking about water and sewer, but what about roadway? I mean, with this coming in, I know the developer's gonna put some improvements, roadways, but it's usually not everything. So where are we at as far as, working in conjunction with Wilsonville, since it's adjoining, and with Washington County, because Washington County controls Woonsbury Road. That interchange we know is not the greatest already around Commerce Circle. Where's the conversation there about the roadway infrastructure?
So we've met with Wilsonville recently. We've met with Sherwood as well. We've met with Washington County. And so, I mean, where it stands on the roadway equation is that, as you pointed out correctly, new development will have to build its frontage improvements, and then it'll have to build any infrastructure that it basically triggers offsite through, which is based on a present day analysis of the trip generation that it creates. There's also, as we've done with other projects, the opportunity for developers to build additional infrastructure above and beyond their impacts in exchange for TDT credits. And so there are those opportunities there. And then, I mean, basically you have the kickstarting of the tax increment financing. And so road projects are among those that are listed in the urban renewal documents that the council's adopted. And then, I mean, how that works out in the long run, Washington County has at least expressed some interest in the city ultimately taking jurisdiction of Graham's Ferry. And so obviously an improvement district through, through basically a combination of frontage improvements, and then not dissimilar to Orland Road, the way the council accepted that piece from Clackamas County. I mean, that's a potential scenario where ultimately there's an opportunity for the whole road. And if you know Graham's Ferry well, it's not really exactly built to an urban standard all the way through town, and that's a real big problem. And so it's actually like an opportunity to fix that problem at the larger scale. And so I think that there is a lot of opportunity. And then working with our partners, I think we're just going to have to continue to work with them to support their contributions through the regional transportation plan and other things. As it is right now, I mean, Wilsonville has additional projects that they've identified in their transportation system plan. We've talked to them and said, like, hey, do you have like a, identified constructible project that we could start, like, taking development and saying, okay, you need to pay a fee in lieu for this impact that you have? And they said, no, not yet. So that's probably the next step in the equation is that they would do that. And then we could have projects contribute to it through development, which would be great. But I guess I would just say that, like, nothing is a perfect case scenario, but obviously kickstarting the development of the zone and then allowing those other mechanisms to take shape is probably a good outcome.
We gotta make our recommendations to the planning commission. So on that one slide, we've got the commission is looking for two options. One is, the other 70% is any combination of warehousing and wholesale sales, or the other option is 35 to 35. So,
and I'm sorry, we've actually revised that slide. That was a misunderstanding
back up.
on my part. Yes, please. Sorry about that. It's just the 70%.
So the 35 is off the table now.
Yeah.
See, I didn't realize that.
That's not what my planning commission notes say, so.
All right.
um,
So then we're looking, how do we feel about that? The 30% would be manufacturing and the other 70% would be a combination of warehousing and wholesale. What's our recommendation to the planning commission?
I'm concerned. I'm just gonna say I'm concerned because, you know, when we look at these development zones that we've done, downtown redevelopment is gonna go slower because once you build it and you try to redesign it, it's a lot harder than building it right the first time. So, so I just feel I'm very cautious about all of this because we're not just talking about how much traffic, but how heavy the traffic is and all, like weight wise. And then I still keep going back to who works in this employment lands, like we've been calling it employment lands. And I don't want to say employment lands in a way that is disingenuous. I just feel very sensitive about it right now. So I'm just putting that out there. I don't feel like, and especially because the choices have changed, I feel a little bit like confused.
The thing I'm putting in my head is, you know, we're not approving the PTA tonight. We're not doing it. That's gonna be a later hearing. All we're doing is giving feedback back to the planning commission on how they should proceed, you know, with their continued deliberations on this. So, you know, I'm sure it's gonna be back with us in
Yeah.
months to come, and we can beat the heck out of it then.
But I'm just saying
Yeah,
that's my
yeah,
concern, and
exactly.
that's
Yep.
what I would say to the planning
Yep.
commission.
Yep.
I think that our community is very very mindful, and if it goes slower but better, I don't have a problem with that.
Others? Taco.
I agree with Counselor Brooks' comments, and I'll also add that, you know, it really sounds like the Planning Commission has been, you know, doing some great outreach, and we've gotten feedback from certain organizations within the community. But I do agree as well, once you build it, and I had some concerns about like just the longevity of this type of buildings, but you provided some context in that in the amendments. I appreciate that. The attachments, I appreciate that. But I too, I'm hesitant, but at the same time, I think that they're, you know, they're listening, and I appreciate that.
What's our recommendation to the planning commission? Again, remember, we're not approving any kind of action tonight. That we're asking them, okay, say we approve the 70% flexible, run with this. And then, you know, our planning folks will come back with the PTA. That's where we can really get in the nitty gritty and, you know, ultimately maybe change it again. That's our prerogative. We want to give our planning commission clear direction, at least at this point, on how to proceed with it.
You're on the right path.
Yeah, so,
But is that what we're saying, or are we saying what?
well, we're gonna, if we, you know, the ask tonight is, go back and tell the planning commission, yes. City council supports your planning so far, your proposal of, you know, 30% of a building would be manufacturing, and then the other 70% would be a combination of warehousing and wholesale sales. That's different from our original plan of manufacturing park, you know, so it's quite different from our guidance from 10 years ago.
What we're saying, because there's no infrastructure,
There's nothing there.
so we can't expect that.
So I know we're focusing a lot on the, land, when we say high paying jobs, we're thinking of land research, we're thinking of, AEA. But, let's not forget there are other, companies that we can compare it to. So what would a company like Pacific Foods be? What category would they fall on? Because they do employ thousands of employees, all 24/7, 7 days a week, and they have good, high-paying jobs in a way of hourly, and, you know, they compensate their employees pretty well. So what category is that kind of business fall into?
It's a food manufacturing. So I mean, it's a type of manufacturing.
Okay, so it's not the warehouse. So can you give me an example of what a warehouse is again? Or the warehouse that,
It would just depend. I mean, that's part of it is that sometimes some businesses have that as a component of their use. And so of course they store a bunch of product before they ship it out. And they may even wholesale sell it. And so any kind of manufacturer may have significant needs to do, or they may, depending like warehouse component parts to make something together. It's kind of varied. I mean, part of the issue is that we can't, I mean, other than to say we're not going to allow certain uses, we can't necessarily, without external forces that are unrelated to the zoning code, we can't make a certain business come here. And it's hard, given our limitations, to attract businesses nowadays. I mean, it mostly goes through Business Oregon, and
I understand that. I guess I'm trying to, because you say 70-30, right? Is the 70 would be manufacturing, 70 would be warehousing, 30-70?
30 manufacturing,
Sorry,
70
yeah.
accommodation.
Whatever he said. So I'm trying to, in my mind, visualize what that looks like, what a business of a manufacturing looks like, and what a business of a warehousing looks like. So for instance, I have seen land or property filled with Amazon trucks. What is that? Is that
And so-
consider a warehouse or?
that would be, I mean, that would be distribution, but that's where the building square footage comes in and limits it to a smaller building that an Amazon wouldn't go into. And so the more likely outcome is that it's like, let's just say, you know, maybe a half dozen different tenants. And so it's not all one use. And so like Schnitzer, for example, who's one of the stakeholders, they have a place in Wilsonville called Commerce Center. That's off of I-5. And so it's similar to that. I mean, it's not dissimilar to the MP zone of like, I mean, it's campus appearance and it's like very clean and, you know, well landscaped, and it's just everything's buildings and parking. There's not, you know, outdoor uses. There's not smokestacks. You wouldn't necessarily know it as a different use from any other uses. It wouldn't necessarily look any different than Pacific Foods from the outside. It would just have a whole bunch of other different tenants. And Pacific Foods is, again, it's like a purpose-built building for a specific user, which we see less and less of.
I just, because if you're asking us what we want to buy, I just want to make sure I understand what's different, the percentage of manufacturing, the percentage, and an example, so I can be more careful what I direct. I like the idea. I too feel that I want to have more of the businesses where we have people working and, you know, like similar to, you know, Lamb or, I just want to say Pacific Foods because I know
Would that
it's
be
right
one of-
here nearby, but that's what I'm thinking, more of that. But, doesn't seem like a lot, 30% for the manufacturing, but then I'm not.
Yeah,
for-
that's,
I mean, not manufacturing, for the warehousing and land use only.
these are multiple buildings. As he was saying, it's more likely, maybe, you know, the buildings might not just have one single tenant. It might be multiple tenants, and what the decision is, in that collection of tenants, you know, one tenant might be just doing strictly warehousing, one might be wholesaling, one might be doing, but they just gotta hit that target of, okay, at least one tenant inside that building,
Okay.
you know, has 30% of that is
Or
manufacturing.
in many.
But the
buildings.
other 30% of the building, you get a variety of different other tenants. That's the flexibility the planning commission is asking us, do we agree with?
So could we just say that we have a concern about employment densities?
Yeah, you can send this back. We can,
Yeah,
all this stuff's gonna be reported back to the planning commission.
right, back to them, that's a big employment and the weight, but part of it is like, when you switch from being like a Lamb Research to smaller companies, you're not necessarily gonna have the same wage equity because bigger companies tend to pay more.
Okay.
Not always, but I mean, in general, like smaller, what we're doing now, it's not gonna,
Like
That's a
office space,
trade-off.
we're not calling to that, right?
Yeah, just.
Office.
So, the Amazon building is about 200, and I think 10,000 square feet. Is that correct? The one that was built, 200,000 square feet.
yeah.
Close to 3.
So 150,000, based
We
on my
have that.
experience and working and taking care of landscaping for, it would be like a facility like Mohawk, correct? Mohawk has a multitude of small buildings, probably about 20,000, 30,000 square feet buildings. 150,000 square foot is a good size,
Mhm.
because not everybody's big business. We have medium business, that's actually the predominant force of, and small business. And it's nice to be able to have 150,000 square feet as an example, where you can partition off 70% for mixed use. It really creates a lot of opportunity for small business to flourish, to not commit to the big buildings at one time. Because the Amazons, the Lambs, you know, those are big. Those are, that requires a lot of land mass. 150,000 square feet is just seems about right in looking at the kinds of buildings that we have, the industrial area where the restaurants at. Those buildings there, those are those kind of mixed use businesses. Is that correct? They're in Tualatin as well.
Yeah.
Windistria, Mohawk, Commerce Center. Every one of those are just suited just right for, even if they want to do 70% and take up 2 spaces, you know, I mean, we can't control that, of course, but limiting the manufacturing to 30%, it seems about right, because what those types of manufacturing typically would want something bigger, you know. We're trying to go after companies that will, we would encourage small business, medium-sized business. I don't know if, I feel like I'm going in circles here, but it seems like they're right-sized businesses. And in some of the examples that are provided here to us, Mohawk is a good example of a good-sized business park, you know, that can actually be landscaped correctly and make it look as part of the community. So I would be in support of something 150,000 square feet as originally proposed and we talked about here. So
Where we at with this? Yeah. Give this back to the planning commission at the 37th. I'm good? Good. All right.
And we'll be sure to forward your other concerns and provide them a link to the video if they want to watch individually. Thank you.
Thank you.
All right. Yep. That brings us to council agenda review. Anyone have concerns with what's on the consent agenda tonight? Well, shaking our heads, all right? All right, and then I think I have, who's up for pledge? I think it's you.
No, Hilliard.
Council Hilliard, you're up for pledge tonight. All right, since we don't have much time for council communications, I'll go ahead and close down the work session. Folks can take a break and we'll kick this off at 7 o'clock.